So anybody that would like to get in touch with the team, please respond back to the email that you received from TiE Phoenix with your information, and then we will connect you with the Chugh team, and it would be fantastic if you can help each other out. So that would be great. So let me take a minute to thank you all. Your expertise is invaluable. Thank you for taking the time to talk to our team. We are going to distribute this. We know we had a lot of attendees that had signed up, but they could not make it for some reason or the other. In fact, even as late as this afternoon, Asha noticed people signing up. They haven't been able to make it. So we'll distribute this recording. We will post it on our website, and hopefully that will help people that could not join today.
We're going to start with our speakers. We have four. We have Miss Dia Matthews. She's our attorney from our New York office. We have Jagan from our Virginia office. We have Miss Carmen Lopez from our LA office, and Mishita. She's from our New Jersey office. She's an attorney as well. Everybody leads a team. They've been with the firm for over 15 years, and they lead a team of anywhere from 7 to 22 people. We have 11 offices in US and another 11 in India. So we are global, and we want to start. So there's something we wanted to share with you, with the TiE people, that when we talk about immigration and our firm, how we work, because we have these 4 departments, we have accounting, and we have immigration and corporate and everything. We have this made up guy called Ram Babu. And there's a joke in our, not a joke, but there's a fun way to learn. And we say that, okay, how do we bring him here in US? What should we do that he remains in status all the time? There are random questions. They'll be like, okay, now he's in US, what next? File taxes. So it's a collab of all our services that we try to incorporate. But today we're going to, because it's immigration based, we're going to just talk about how we bring Ram Babu to US and keep him in status until he's a citizen. We're going to obviously start with the F1 option. Carmen, how are you doing? Happy birthday again.
Oh, thank you so much. I really appreciate the invitation to participate in this. I'm excited to be part of it and be able to share knowledge with you all and sort of give you some, tips on F1s and some good information for students, because I think that's a very good option for a lot of people. So we'll go ahead and get started then. Is that okay, Vinny? Or I don't know, should I take it forward now?
Yes, Carmen, let's go. Let's Ram Babu has what do we call it? A 4-year degree from India. Let's say computer science. And what's next?
Okay. So he has a 4-year computer science degree. And of course, in order to maintain status, he has to be enrolled a full course of study. And while he's going to school, a lot of times students ask themselves, like, can I work? Can I work, off campus while I'm going to school? And the answer is yes. There is what's called curricular practical training. That is called CPT, the acronym CPT for curricular practical training. It's a authorization that's given to students while they're going to school. And they can work 20 hours or more. This is something that I would like to really stress, is that, a lot of students, once they graduate, they want to get what's called OPT. That's optional practical training. That's employment after they graduate. But in order to be able to get the OPT, they have to limit the CPT to 20 hours or less if they're going to be on it full 1 year. Okay, so if they already have, let's say, 40 hours for a year for CPT while they're going to school, they basically don't get the ability to do the post-OPT. So it's important that they limit it to 20 hours so they can have that OPT. A lot of times these students want to change status eventually to H-1B, and they want to take their chances in the lottery once, twice, the year after. And so it's best to try to make that ability to be on F1 through OPT as long as possible. So now, you have the CPT, you have to have an offer from an employer. The CPT must be related to the program. They work on it, they get an I-20. They cannot work until the I-20 is issued by the school. And so once the I-20 is issued, for the duration on the I-20, so you have to be careful. You look at that. Don't want to violate your status, not even a day. 1 day of violation anytime during the F1 process will bring consequences later on when trying to change status to H-1B because of even a day violation. But so now, Ram Babu has CPT. He's worked 20 hours, while going to school. Maybe he's had 2 employers. He gets, various I-20s for 20 hours. Then he's about to graduate. So when is the next step? You have to then file, once you're about to complete your program, that's 90 days before the completion of the program and no later than 60 days of the completion of the program. There is a timing, so you have to calendar those dates to file what's called OPT. OPT is work authorization that is issued after you graduate, and that is for 12 months, okay? You cannot work until the OPT is actually issued, okay? The good thing is now there is premium processing for OPTs. The filing fee for that OPT is $16.85, okay? So you pay the filing fee of $520 and the filing fee of $16.85 if you want to do premium. That way you can get your OPT issued as soon as possible. Again, you cannot work until it's issued. That OPT is for 12 months. You have to work at least 20 hours a week. You could work with multiple employers. So, you could have various I-20s while on 12 months. The employment can be unpaid or paid. As well as actually the CPT, going back to CPT, that could also be unpaid or paid. The 12-month can be unpaid or paid. And a lot of times students ask us, can I open a business while on 12-month OPT? And the answer is yes, you can run a business through the 12-month OPT as long as the program is related to the employment you will do while on 12-month OPT. While you're on 12-month OPT, keep in mind a few things. There's a lot of violations that can occur. You're excused 90 days. That's 3 months of not working, of meaning not having a job. And so a lot of times students are trying to find employers as soon as possible to minimize that unemployment period that they're able to have not having a job, okay? And that 90 days within the 12-month window of that work permit. So once it's issued, that's when you can start working, and then it expires 12 months later. So within those 12 months, you're excused 90 days of no work. Okay, so moving on, if you are a STEM degree holder and you want to apply for an additional 24-month STEM extension, those are for your STEM people, your science, mathematics, engineering, or technology. You can file before the 12-month expires an extension for 2 more years. Now, the difference is that for the 24-month, there are a little bit more requirements, than the 12 months that we just talked about. The 12 months doesn't require too much. It just requires an offer from an employer in a job that relates to your job for 20 hours at least. But for the STEM, that one requires that the employer who is going to sponsor you, to help you get that 24-month must be registered with E-Verify. If you're not registered with E-Verify, you can do it on the USCIS website. You have to take a tutorial of about 45 minutes. You'll get a registration online right away. And that's the first requirement, is an E-Verified employer. The second requirement is that they must complete between the employer and the student a training plan. It's Form I-983. Form I-983, that form needs to be completed and signed. It talks about the training that they will receive, the job title, the duties, the location, the manager who will manage you, the way that you're going to assess the training that is being received, okay? And any change in those training plans must be notified to the school's designated official within 10 days. So what happens is you get these two things: E-Verified employer, second, Form I-983. The student goes to the school, they give it to the DSO, school designated official. They will issue an I-20. again for 20 hours. Now this employment must be paid, okay? Unlike the CPT or a 12-month OPT that does not have to be paid, it could be unpaid internship. The 24-month requires payment. You know, a lot of times you get, well, how much? You know, any payment that is at least the minimum state minimum wage without, you know, violating any labor laws, okay? So that is fine to do. So they submit the I-765 with USCIS with a filing fee of $520, and they will get the work permit issued. Again, there's premium processing for this, but the good thing about the 24-month that is not there for the 12-month is that you could work with a receipt notice for a period of 180 days. So let's say that your OPT for 12 months is expiring today. Today is February 24th. As long as your extension is reached on or before the 24th of February, you could work with a receipt notice still, okay? Now, you don't have to have it issued like the other one. Now, another important thing to know is that you are allowed 60 additional days of unemployment with the with the STEM OPT, right? So again, remember 90 days for the 12-month, an additional 60 for the 24-month STEM extension. So for example, if you didn't use any of the 90 on the 12-month, they put it over to the for the 24-month, and you'll have a whole 150, right? Because it's 90 plus 60, but if you don't use the 90, you could use them over to the 24 months. So once you have the OPT for 24 months, you have a work permit for 2 years, you could change employers, but anytime you have a new employer, they must also be registered with E-Verify and do the I-983. The only thing is you don't have to submit the I-765 anymore because you already obtained the card for 2 years. So no need to keep submitting another I-765 again and again. Once you're done with your STEM, well, you know, you have the abilities to, you know, do the lottery, and if you don't get accepted, you could go back to school, and, you know, as long as you get another I-20 with another school, people do sometimes second masters, you know, they go up the ladder. Important to know too, really quick before I pass you on over to, you know, Nishita to talk about H1s, is that the STEM OPT is limited to the ladder. So for example, associates, you could do CPT, then 12-month OPT, but you cannot do 12-month OPT on the same level. Once you go to bachelor's, again, 12-month CPT, 12-month OPT. If it's STEM, you get the 24-month. Then you go up the ladder to master's, CPT, 12-month OPT, 24-month STEM OPT. And then you can go up the ladder again to postdoctoral. That's CPT, 12-month OPT, and STEM if it's STEM degrees, okay? But if you do a second master's, let's say you got a master's in computer science, but now you want to get one in computer information systems, if you've already used up the 12 months of OPT and the post 24-month STEM extension of OPT, you're no longer allowed to do the OPT again, okay? So I'm, you know, done with that. I'm sure there's lots of other questions, but I want to leave time for the others to, you know, talk about the other visas, okay? So I'm passing it on to Mishita, where she will talk about, you know, the next visa.
Carmen, before Mishita, we have a question quickly. So if somebody's worked, say, full-time CPT for 6 months, can they file for OPT?
6 months, yes. As long as it's not more than 12, yes, as long as it's not 12 months or more, okay? Again, it's limiting it. If you do 40 hours for just 6 months, that's okay. And you will still be able to get the post-OPT for 12 months. No problem.
Perfect. Thank you, Carmen. Mishita, you're next. Indians' favorite visa, kind of visa, is H-1B, right? You're next. Mishita, tell us about H-1B.
Thank you so much, Vinny. Let me also thank Mr. Kannan for having us. We're very honored to speak with everyone at TiE Phoenix and wish you all the best with the start of this new chapter. So moving on to Ram Babuji, who has now finished his graduation and hopefully has found an employer to sponsor him at the end of his initial 1 year and then 2 years of STEM OPT. Just a quick sort of backstory here is that while he is working on STEM OPT, he should keep asking his employer every year to keep putting his name in the lottery. So the H-1B visa category is a visa category for specialty occupations. Basically, think of any kind of professional services, professional occupations. It could be software engineers, it could be doctors, it could be lawyers, it could be healthcare professionals, scientists, architects, anything that requires a US bachelor's degree or equivalent is a specialty occupation. Now, hopefully, the employer that is employing Rambabu was able to put his name in the H-1B cap lottery. This is important because the first time that someone is able to change status from F1 to H-1B or any other visa status to H-1B, they need to be picked up in this lottery selection. Obviously, historically, the numbers of the visa numbers for H-1B have been, there's been a cap limit, 65,000 for those who are in regular degrees and another 20,000 for those in advanced master's degrees. But the number of people who apply is significantly higher. Therefore, the USCIS conducts a randomized lottery, typically in the month of March. And this is where any individual who is eligible, they can be put through in the lottery. In the earlier years, many years ago, it used to be that the employers had to send the entire package, the entire petition within the first 7 days, working days of April, and then USCIS would pick the petitions to fill up the visa numbers. But over the years, USCIS has modernized its ways of working, has made it more efficient. And now instead of sending the entire visa petition, the employers and the employees, potential H-1B holders, they just need to register their biographic information. So just, their name, their passport details, etc. they can be put. And if they are selected in the lottery, then the employers have up to 90 days to submit their H-1B petition. This is helpful in some ways because it also gives the employers, some time more to think about whether or not they are able to sponsor the foreign national. Sometimes things might change from initially when their names were put in the lottery. The USCIS has also made it more employee friendly or foreign national friendly now, such that if there are multiple employers who are submitting the employee's name in the registration, it would still be counted as one unique entry. And, that way, nobody is able to sort of game the system by having multiple people submit their names, because that was also a concern that was raised, that if the same foreign national is able to get multiple employers, submit entries for them, they were somehow gaming the system. So USCIS is continuously trying to, make the system more efficient. Now, assuming someone does get picked up in this lottery and their employer is able to submit their H-1B petition within the 90 allotted days, H-1B petition or H-1B status is up to a period of 6 years, with 3 years in the initial H-1B, and then it can be extended for another period of 3 years. After that, unless the foreign national is at certain milestones in their green card process, which they will be speaking to in greater detail later, at the end of 6 years, then they have to either go back to their home country if they have not reached the green card milestones, or they have to figure out another visa category to change to. Now, let's say, hypothetically, that Rambabu is not able to get picked, since this is a random selection in the lottery. Let's say they tried the first time, second time, third time, and they were not picked up. One option that could work for them is that if they were working for an employer that has offices overseas, any place outside the United States, let's say they have an office in India, Australia, London, Singapore, and if they have an entity over there which has a qualifying corporate relationship with the US employer, maybe the company in India is a wholly owned subsidiary of the US company, maybe it's a branch office, maybe it is an affiliate, such that both the US entity and the Indian entity are owned by the same parent. In that case, if Rambabu has worked in one of these offices for more than 12 months, in either a specialized knowledge position or in a managerial position, then he could potentially be brought back by his employer on the L1 visa or an L1 visa. Now, although the statutory requirement is 12 months, we always recommend that Rambabu should spend, at least 18 to 24 months in the company abroad, wherever he goes. That is so that whoever ends up filing the petition for him is able to show that he really gained specialized knowledge over a period of 2 years in the company abroad, or really worked in the managerial position, and then Ram Babu can be brought back. The biggest advantage of the L1 visa is that it is not subject to any lottery, and it is not dependent on any time throughout the year. As I mentioned earlier, you might recall that the lottery takes place, during March every year. And after that, once somebody is selected, then their petition is filed. So, if unfortunately an employer is not able to submit someone's lottery during the registration period, which typically runs for 2 weeks in the month of March, then that person has essentially lost an entire year. So that's the advantage of the L1 visa, is that the L petition can be filed at any period of time. It is not dependent on, a certain time in the year. The other big advantage of the L1 visa is that the spouses of L1 holders, which are the L2 visa category, they have work authorization built into their status. With the H4, which are the spouses of H1B holders, they don't have automatic work authorization. If the primary H1B holder reaches certain milestones in their green card, then the spouses on H4 could technically apply for, a work authorization permit. But with L2, you don't have to apply for any work authorization. The mere fact that you have L2 status is enough to be work authorized. And the good part about that work authorization is it is not tied to any particular employer, any work location. So for all you know, Ram Babu's wife could decide that once she's here on L2 visa, if Ram Babu is in New York, she could go to Phoenix and, start something on her own there and be employed there. One thing, given that, we are talking to everyone at TiE, something that could be advantageous is that recently USCIS has come out with more clarifications where everyone's been asking, well, what if I do my own startup? Can my startup sponsor my H1B? And the answer, like any good lawyer will tell you, is it depends, or it could be yes and no. So the way it depends is that if Ram Babu owns this particular startup, he still has to show an employer-employee relationship with the company. So if Ram Babu is the one making every decision, if Ram Babu cannot be fired, then clearly he is not an employee of the startup. But if Ram Babu owns, a certain percentage in the startup, but he can still be removed. Maybe there's a board of directors. Maybe there is a CEO that Ram Babu sort of, reports to. Then that startup could technically file an H1B petition for Ram Babu. Obviously, it will be a little bit, there will be a little bit more that the employer will have to submit, as opposed to if Ram Babu was, let's say, being sponsored by the Googles and the Facebooks of the world, where it is, distinctively clear that they are the employers and Ram Babu is just an employee. But having said that, it should not be discounted that if Ram Babu were to own a startup or be a co-founder in a startup, that startup could also file the H1B for him. So, which is great. And, it should give even more impetus to Ram Babus to start their journeys as entrepreneurs and, found companies here. I think that obviously there's so much more that can be talked about as far as H1Bs and L1s are concerned, but I do want to give an opportunity for the other visa categories also. So before we move on to Jagan, I just wanted to see if there were any questions, Vinny, that we could answer.
Right. Mishita, there's, thank you so much. There's one on the chat. If Ram Babu wants to transition from cap exempt H1B to cap subject H1B, have the rules changed with new administration? Do they have to go to lottery process again?
Yes, that's a great question. So, and I think to give the answer, let me also quickly take 1 minute to talk about cap exempt H1Bs. So as I talked about cap subject H1Bs, which is, everything about the lottery, there is a special category of the H1B which does not require to go through the lottery. And these are for positions in either higher education, research positions, or positions which could be in for-profit entities, but they themselves are related to research positions. So maybe if Rambabu has, founded a healthcare company which does some deep research in conjunction with, let's say, Purdue University or the University of Arizona, then that petition, then that healthcare company could file a cap exempt H-1B for him, which does not require to go through any lottery, and it can be filed at any time. But let's say if Rambabu was on a cap exempt H-1B petition, and at some point he wants to move back to cap subject petition, he will have to go to the lottery. So let's say in November, if Rambabu is told by his employer, which is the University of Phoenix, that he is no longer required for that, at that employment, he will not be able to just jump from a cap exempt to a cap subject H-1B in November. He will have to wait all the way until March. And that's why in the interim, he would have to either find, someone else to file an H-1B cap exempt petition for him, or to get to another visa category. And even in March, once he is put in the registration, he will still have to be selected and then have someone file the cap subject petition for him. So great question.
Thank you, Mishita. There's another one before we move to Jagan, and then if there are more questions, then we'll go towards the end of the session. If one gets selected in H-1B lottery, but the employer cannot employ one selected, then can that person find another employer who can sponsor the visa but not go through lottery again?
Right. So this is a little tricky because although we talked about the lottery becoming, more foreign national centric, but what happens is that once the lottery is picked up, it is still for a specific employer, right? So right now, we would need that particular employer to at least file the H-1B petition, the first one, for the H-1B petition to be filed. Thereafter, let's say if, that employment cannot continue, and after a few months, it seems like that employer is going to let Rambabu go, then another petitioner or another employer could file an H-1B transfer or H-1B change of employer petition. But that initial lottery will have to be filed by, whoever was the employer for whom it got picked.
Right. Perfect. Thank you, Mishita. Thank you so much.
Thank you so much, Vinny. Over to you, Jagan.
Jagan, you're next. Tell us about O1. That's the new, what do you say, new favorite, where everybody wants to go. Tell us about O1. You're on mute, Jagan.
I'm so sorry. Thank you, Vinny. Thank you, Mr. Kanan, for this. I'm going to explore about the alternatives too, because our Rambabu could be a person who could be making ground-breaking discoveries, or an entrepreneur disrupting industries, an artist creating renowned work, or an athlete breaking records, or he could be one of the winning team member of the World Cup cricket team, or something like that. So we want to see, these talented professionals have an alternate path to come and work in the US. So for those kind of people, O1 might be the best way to work in the United States. What this really means is that the O1 is actually designed for individuals with extraordinary ability, meaning that you must be at the top of your field. It's just not good, but extraordinary ability. And what that also means that O1 is based on merit. The O1 comes in two flavors, O1A and O1B. O1A is for individuals in science, business, education, and athletics, while O1B is for professionals in art, film, and television industries. So if our Rambabu is the primary O1 talented professional and has team members or assistants, then those supporting individuals can also apply for O2 visa to accompany the O1 holder. So they can accompany Mr. Rambabu on O2 visa. So this visa is typically granted for 3 years. and can be extended in 1 year increments if the work continues. So as I was mentioning before, O1 is a merit-based visa. So what it means is to qualify, an applicant must prove that they have extraordinary ability, that they belong to a small percentage of people who have reached the top of their profession. And that requires submitting strong evidence to the US government, which can typically include, according to the criteria established by the USCIS, it could be major national or international awards. It could be memberships in elite organizations that require outstanding achievement, or it could be original contributions in major fields, or a significant media coverage in major publications, or it could be published scholarly work or critical reviews, or a demonstration of high salary or remuneration in their field. So I would just like to give some various obvious examples of some of these. It could be like Ram Babu could be a tech entrepreneur who has developed a widely used software and received recognition. Or he could be a professional athlete who has won championship or was featured in major sports. Or he could be a filmmaker whose film was screened at Cannes or Sundance. Or he could be one of those singers who performed in one of these major events. So why do people choose O1? The typical reasons is because it's not subject to cap. There is no annual limit. You can apply as many O1s as you want. Premium processing is available. If you go for regular processing, you could see a decision being given to you in 2 to 3 months' time, unless that will change in the near coming future. It's usually given for 3 years and has unlimited extension in 1 year increments. Then there is an easier path for green card, which will be covered by my colleague later on, which works in a mirror fashion, meaning whatever works for O1 can also work for an EB1A. So the application process is pretty simple, but it would require you to submit a job or a contract supporting evidence, like I was discussing earlier about awards, publications, media coverage, etc. Sometimes a consultation letter is required, which is an advisory opinion from a recognized organization in the field that they have no objection. So despite its benefits, I would like to put a word here that the adjudication standards is a bit high. So you have to go with a very good package when you submit it to the USCIS. So you should submit sufficient evidence that demonstrate that you are extraordinary, not just good, just extraordinary, meaning if you think things could be just achieved with a simple resume that would highlight all your achievements, probably it's not the best way. And your documentation must clearly prove that you came out to the top of the field. One important aspect that I would like to discuss that was also touched upon in the HNL is self-sponsorship. So many people like Rambabu would come and ask, can I do a self-sponsor? So yes, self-sponsorship is available, but there are some specific conditions. So unlike other visas that require direct employer-employee relationship, O1 allows for agent-based sponsorship, which provides flexibility for independent professionals. So an agent could be, for example, a person who's representing you as well as your company. So this is commonly used by freelancers, entrepreneurs, and artists. So if you work on multiple projects, like you're a consultant, performer, or you're on a short-term contract, you can have a US agent act as a petitioner. This could be a talent agency, a business manager, or even an entity that you create for yourself. So you can simply create a US entity like an L Corp, LLC, C Corp, S Corp, etc., and have it petition for you on the O1 visa. But one significant factor is that you must prove that you have a legitimate business And there is a distinction between you and the company, which means that we have to prove that this is not a shell company. And the company must have projects or contracts or funding lined up. If you have a company which has a co-founder or a board of directors, then they can help establish the employer-employee relationship by being the petitioners. Well, this is a good way to secure. You must also keep in mind that you must still show, even as a sales sponsor, that you have risen to the top of the field, that you must show national and international recognition. There must be clear employer-employee relationship established. So USCIS would scrutinize your job duties to see if that factor exists or not. And you must prove that you have sufficient work lined up through contracts and also financial proof. So this is pretty good when it works for you if you're an entrepreneur, startup founder, freelancer, independent consultant, independent contractor. Thank you. Winnie, back to you.
Thank you, Jagan. I have a question actually. So do you anticipate any challenges, getting your petitions approved with this new administration, especially with O1s and Ls that are, scrutinized already?
Yes, I mean, what you're seeing is a lot of people are going into niche technologies, AI, for example, and they are frustrated with the lotteries or the chance of Trump administration changing rules on how the established employer-employee relationship in et cetera, as we have seen in the previous administration. So they like to go and occupy a visa category where there is a lot of freedom to do something for themselves and their and the company, or grow for that matter. So it won't be a surprise if this O1 category is going under scanner. And it's in the nature of USCIS to come and try poke holes in our story and try to downgrade and say, hey, I don't see an international recognition or national award, or some strike and say, hey, I don't see as a significant achievement and all. So we should not be disheartened. We should go and push back as much as possible with greatest documentation we can provide. Letters from contemporaries, letters from senior professionals in your area where you can establish, for example, if it's an AI product, you could come back with several letters from industry and say this is a groundbreaking development. It's a very niche technology. It's going to disrupt the industry, et cetera, and then you can still make a case. So just because USCIS may challenge your case in an RFE, it doesn't necessarily mean that everything is lost. You still have time. You could do it. Yeah. So challenges will be coming, but we could still overcome it.
Thank you, Jagan. There is a question on the chat. It's how many publications and citations is good enough number for researchers for O1? Do one first author article count?
Yeah, so the regulation does not prescribe a number. The content is what is more important. Even if it is one article or two articles, that should be sufficient. But most people professionals like to say, if you have some lined up, then you can show continuity in your work. That you have. It's not just a one-time thing that's occurring. That you have lined up a lot of background for yourself to show you went to the top of your field. But having said that, it doesn't necessarily mean that there should be a certain number. Even 5, 4, 3, any number would do.
Thank you, Jagan. You rightly said if the petition's prepared well, this is based on our experience too. We've had O1 approvals with no RFEs, nothing at all, and we're very proud of that. So bottom line is make sure we meet all requirements and submit the petition in a perfect format.
Yeah, you said it right. I mean, we had one success very recently. An individual who happened to be appointed as a commissioner for business in one of counties in Australia for a 6-month term, and ended up getting an O1. So it's all in documentation, genuinity, and making your case. Yes.
Right. Thank you, Jagan. Moving
you.
on, we have our final speaker, Miss Dia Matthews from New York. Dia, our poor Rambabu's not single. Otherwise, we could have just filed a green card for him, like get married to a U.S. citizen. But thankfully, he's married. He has family. Tell us about his green card path.
Okay, all right. So first of all, Balveen, thank you for leading or guiding Rambabu through this maze of visas, right? And thank you all for coordinating this, TiE Phoenix. So let's talk about the green card options, right? And so this is usually what happens, especially for Indian nationals who come here. They know it's going to be a very long path to get the green card, right? So when a client comes to me, a client such as Rambabu, you have to be upfront with them. You have to tell them that if you're looking at green card sponsorship through employment or through family, it's unless you're getting married to a US citizen, you're looking at a pretty long wait time. With most folks, you can only do an EB2 or an EB3, and these are acronyms that we use. But in the EB2 and the EB3 queues, you're looking at wait times of 15, 16 years and probably upwards for internationals. Possibly the only visa, the green card category, which is current at the moment, which means that there is no additional wait time. It's just the USCIS processing time. So the only category which is current at the moment like that is the EB5 set aside category. So even the EB5 category has multiple subclasses within that, but there's a small percentage of EB5 visas which are reserved for investments in high unemployment, rural areas or infrastructure projects. So that's what we call the set aside categories, and that's really the only category, the green card category at the moment, which is current for Indian nationals. And so it used to be until a few years ago, before the pandemic, until 2019, it used to be that you could invest $500,000 and be eligible for the green card, the EB5 green card. But with the recent changes to the program, now the investment amount is closer to 800,000 in the TiE, the designated areas, or the normal investment amount is a little over 1 million. So if your country of birth is India, and for the green card queue, it always goes by the country of birth. So for somebody born in India, the EB5 is really the only category which is quick, relatively speaking. So now, what's the requirement? Let's talk about the requirements. The first requirement, obviously, is that you should have this amount, the investment amount available, you have to be able to demonstrate a lawful source of the funds. It can be gifted money. So your father-in-law could gift that money to you, which actually happens, right? A relative could give the amount to you. It could be a loan, but it cannot be a loan to the EB5 entity, right? Whether it's a regional center or a direct investment. I'm not going into the details of that just because the time constraints here. But it cannot be a loan to the entity, although you can source the funds through a loan. And usually, we recommend that it be secured by collateral if it's a loan of that sort. The investment 800,000 or the 1 million amount should be put into the entity. And the main requirement is that it should create 10 full-time jobs in the US. So it's not just a question of putting in the money. The actual purpose of the EB5 program is to actually generate jobs in the US. So 10 full-time US jobs. And this requirement cannot be met by hiring people on visas. You have to hire a US national, and there's a definition. So that includes citizens, permanent residents, and certain other categories. Coming back to the source of funds, just to highlight here that there's a misconception that you have to bring the funds from outside, but it doesn't have to necessarily be from abroad. You could totally use funds that you saved in the US, right? If you were on H-1B or O-1 or any of those visas that my colleagues talked about, and you saved some money from that, you could use that as the investment amount. We talked about the nationality requirement, so there's no restriction. And then the other thing to keep in mind with the EB5 program is that I did mention that it is quick in the sense that there is no, there's no retrogression. It's really only the processing times that you have to wait for. But even the processing times for the EB5 program are pretty long. So you're looking at end to end, right? Because first you get a temporary green card or a conditional green card. And then during the conditional green card period, which is 2 years, you have to show that your investment created 10 jobs. And then you file a second application for removal of conditions, right? And so that could take about 3 to 4 years to be adjudicated. So by the time you're done with all of this, you're easily looking at 5 to 7 years. So that's, that's one thing to keep in mind. And Ram Babu, I know, is not going to be happy about that. But at least, I mean, if you go through all of these steps, you do end up with the green card. So that's a little bit about the EB5 program. How much time do we have?
Dia, we have 7 minutes.
Oh, 7, okay. So I just want to talk a little bit about E2s also, if there's interest. Investor, while we're on investor visas. The E2, again, it's not a green card category, it's a work visa. But it is an option to consider if Ram Babu gives up at some point here and let's say he decides Canadian immigration is easier, and he decides to acquire Canadian residence and then ultimately become a Canadian citizen. At that point, he could become eligible for the E2 visa. The E2 is, you could think of it as, kind of like a distant cousin of the EB5 program, because it's, again, based on investment. You have to, be willing to invest a certain amount into the US, into a US business. And this investment amount is not as high as it is for the EB5. You could get away with, probably something around the region of 100,000. Again, it depends on the kind of business that you have. But the E2 could be an option for him. But the limitation is that the E2 is a work visa, right? It's not a green card category, so it's always going to be temporary. But it does give you the option of running a business, of doing your own business in the US. And it doesn't have to be a big business. We can do an E2 for a smaller business like a laundromat or like a restaurant or a store. All of these could qualify for the E2, as long as you can show that you have invested a substantial amount of money. Substantial is not defined, but as I said before, like you can do about 100,000 and have a good business plan and explain how you're using the funds. Also, the other requirement with the E2 is that it should not be marginal, in the sense that Ram Babu doing an E2 here should not be just employing himself or finding a way for him to work himself, but he should actually be running a business. And that is generally interpreted as being, able to hire people and give, actually support US workers. And again, source of funds have to be established for the E2. It can be renewed indefinitely. So we have clients who have been on E2s for a very long period of time. But in the meantime, you have to figure out how to get your green card, and that'll probably have to be through some other avenue. So Balveen, I hope that that gives Ram Babu enough of an overview of all these visa options and green card categories.
Right. Dia, we have a few questions here. Can an entrepreneur raise $1 million in funding for his or her entity and file EB5?
Sorry, is this the question I'm seeing in the chat box?
Yes, the very first one. There are three.
Okay.
So
Can an
the
entrepreneur raise 1 million funding
for his or her?
Yeah. So good question. Again, so here you have to show that the funds are secure, right? So he's raised 1 million in funds, investors probably, but it has to be in his name, right? So if the investors have transferred the funds to him and he can show that he's in possession and control of these funds, then yes,
Right.
he can then take these funds and put it into the entity and obtain a green card through it.
Perfect.
But he has to show that the ownership of the funds is now with him.
With
So
him, yes.
yeah, that's the defining requirement.
Thanks, Dia. There's another one. Can a Canadian PR holder, not a citizen, secure a green card in US?
Yes. So that's that's two different things.
Right.
You can be a Canadian resident, obviously, and at the same time pursue a green card. The good thing is you could also be a Canadian citizen, right? Unlike India, Canada doesn't have a restriction on, holding citizenship in another country. So you could have dual citizenship.
Thank you, Dia. There's another one. From what I understand, to get a final green card from EB5, it would take around 5 years, but would like to know the processing time of EB5 visa from date of application.
Yes.
So
I wish I knew the answer. I wish I could give a concrete answer to that. But as I was saying, right, EB5 processing times are crazy. Like if you look at the published processing times, they'll say like 48 months for an application, right? And clients often, they can't believe that that's the case, but it is true. So the first application, if you do it in the set aside category, USCIS is technically supposed to adjudicate it fairly quickly because it's in a priority list. So the first stage you might get through within, let's say, a year. And then you get a conditional green card, which is for 2 years. So in that period, you have to, you don't have to really do anything. You just, maybe waiting for the business to run and the jobs to be created. If you're doing it through a regional center, then you don't really have to do anything. The regional center does all the work. You just give them the money. Now, if the 10 jobs are actually created, then the regional center will give you the paperwork to be able to file the application for removal of conditions. That's the 829 application. And so, you file that and your status is good while all of this is going on because, you're waiting for USCIS to take a decision on the case. What happens is after you file the application for removal of conditions, you probably will not hear back for several months. It could be 2-3 years. And then at that point, you might get an RFE, a request for evidence from them, asking for some clarifications or additional documentation on the creation of jobs. In some cases, they also re-adjudicate the initial issues like the source of funds and things like that. So then you respond to that RFE and then you wait again for them to take a decision. So realistically, yes, 5 years or more for all of this to be completed.
Right. Dia, if the person is in US, say on a B1 visa, can we do a change of status, adjustment of status, and then can they work on this EB5 business?
Yeah. You're going to have to pay me extra to answer that question. But yes, so again, to take a page out of Nishita's book, it depends, right? So
Right.
generally, when somebody comes in on a visitor visa, you are not supposed to have the intent to pursue a green card in the US, right? So that's, that goes to the intent. And so what you can show, did you come in with a return ticket? Did you come in with plans already in place, etc.? If you can overcome that intent issue, then yes, after 90 or 3 to 4 months, that's considered to be a safe harbor. So if you do the change of status after that period, and you can demonstrate that there was a change in your plans, and you did not enter the US with the intent to do this, then yes, you can file the change of status. You can file the EB5 petition as well as the adjustment application together if you're, if the priority date is current.
Right. Thank you, Dia. Thank you so much. Any other questions from our audience before we wrap up? It's 6:01. It's 7:01 in Phoenix. We want to thank Kannan again and Carmen, Jagan, Mishita, Dia. You guys are our experts. Thank you so much for sharing. I was thinking when I saw the topics, I was like, OMG, this requires a separate session. How are we going to lump it up? But You guys did a great job, and thank you so much. Kanan, you want to say something?
I think there's one quick question that's just popped up there.
Sure. It says, any update on perm processing times, and what if the visa gets expired before perm approval? Anybody can answer. Carmen, Mishita.
I'm telling Mishita because I think she answers this question every day.
So the perm processing timelines, unfortunately, are still hovering around 15 months. The good part is that, and I'll try and wrap this up really quickly, is that if your perm has been filed 1 year before your H-1B visa max out, or if it has been pending for 365 days, then you are eligible for H-1B extension in increments of 1 year. So that hopefully answers the question that what happens if the visa expires before the perm approval. But even after that extension, let's say if the person is unable to continue staying in the US, the other good news I have for you is that perm is independent of your visa status, because perm is towards the green card, whereas your staying in the United States is, temporary on H-1B, F-1, O-1, whatsoever. So as long as your employer is willing to file the I-140 petition for you, which is the second part after the perm of the green card process, even if you leave the United States and are back in your home country or in a third country, it will not impact, your priority date. That process can continue independently and parallelly. Of course, I understand that, Rambabu will not be here in the United States, but it will not impede the green card process. So that can continue.
Perfect. Thanks, Mishita. So when do you recommend starting the perm process? We all know that H-1B is for 6 years.
As soon as possible. If Rambabu's employer is able to do it, they should do it on day one. But just given the perm processing timelines and the fact that I-140, if Rambabu and the employer does not wish to pay for the premium processing, accounting for all of that time, I would definitely say in the second year or at most the third year. Like beyond the third year, then we're cutting it very close.
Yeah, we're very late then. Thank you, Mishita. So there's a question, can we possibly schedule a consultant? Yes, please send me an email or send an email to Kanan, and please introduce me, and then we'll have your consultation ready. No problem at all. Thank you so much, Kanan, and we appreciate and giving us an opportunity as well, and hope for all the best to Phoenix.
Thank
and
you.
Of course, at some point we'll show up at TiECon Phoenix.
Yes, absolutely. Yes.
You do it, and we'll show up.
We'll be delighted to have you all. Okay.
Thank you, everybody.
Thanks.
Thank you. Bye.
Take care. Bye, everybody.
Thank you, everyone.
Yeah.
Yeah.